First of all, good morning everyone, and welcome to what is the June edition of our Business Swansea Power Hour. Those of you who have been before will know the format, but these are designed to be short, sharp briefings on a given business topic, and obviously the topic for this month is a really important one, so it's good to see some of you have come along to get that update. Just in terms of a bit of housekeeping before we get into the session properly, just to remind you, this session is video recorded and will be uploaded to our YouTube channel. So just bear that in mind for a couple of reasons. Firstly, if you don't want your face to appear on the video, then just turn your camera off using the little camcorder icon at the top. And then secondly, obviously, just bear in mind any questions that you've got, particularly if it relates to your business, that this will be out in the public domain, hopefully later this afternoon, maybe tomorrow. So just to bear that in mind. If I could ask you to mute your microphones throughout the session, obviously, unless you're asking a question, just to avoid any background noise. And then finally, with regard to questions, if I could ask you to just keep your questions until the end. If anything crops in mind whilst Paul's doing his presentation, either put it in the chat or just make a note of it, and then we'll come back and ask you at the end, sort of via the Q&A session. We'll have about sort of 10-15 minutes available for that at the end. So those of you who have not met, my name is Matt Callaghan. I'm an Economic Development Officer for Business Swansea, Swansea Council, focusing on business support and business engagement. And along with my colleague Steve, we run these sessions along with our monthly Startup Enterprise Club. So what I'm going to do very quickly is just get you to go around the room, introduce yourselves, a little bit about who you are, what your business is, and if you want to, any particular reason that you decided to book on for this session, again, sort of obviously bearing in mind the fact this session is recorded. So if I hand across to my colleague, first of all, Steve Williams, who I've kind of introduced already, but I'll allow him to do it himself.
Morning everyone, my name's Steve Williams, Economic Development Officer in Swansea Council. In my previous roles I was also a HR business partner, and Paul was actually my lecturer at university, hence why he's kindly agreed to come on with some of my previous connections. So really looking forward to today. It's going to update my knowledge because I'm a bit out of date, and I'm sure you're going to find it very, very useful. Thanks, Steve.
Andrea Evans.
Hi, good morning everybody. I'm Andrea. I'm the HR manager at Liquidfin Technologies Group in Forest Rock. I've been a HR manager for many years, know Paul fairly well from previous employment, and he was also my lecturer in college. So yeah, just basically an update. Always enjoy the sessions, so just looking forward to learning a little bit more today and finding a little bit more about everything.
Great, thank you for that. You're a well-known character, Paul, obviously.
Yeah, it makes me feel old, actually.
Dennis.
Good morning. My name's Dennis. I'm a compliance manager for a local transport company in Swansea. And obviously, as a small family business, we're on external HR companies. So I come along to just to get a bit more of an insight, so I don't have to keep harassing them so much if we have any HR issues.
There we are. Thank you, Dennis. Good stuff. Hannah.
Good morning. My name is Hannah. I work for Swansea City Football Club. Recently new to the role as a staffing officer, so just kind of helping the staff. This kind of touches on HR, so I wanted a bit more information on that. I have recently graduated from uni about 2 or 3 years ago with a law degree, so I'm interested in learning more about employment law.
That's super. Thank you very much. I've got someone shown here as Jay. I'm not sure what your name is, but you're showing as Jay on the guest list. Okay. And then we've got Yola as well. Yola, do you want to just quickly? Oh, Yola's gone. Okay, never mind. We'll move on, I think. And I say, if you want to, if we come back and do the Q&A at the end, obviously just introduce yourself at that point if you've not been able to do so during the session. So I hand across to Paul now from DJM. Paul, just introduce yourself, and then we'll have about 30 minutes or so of this session and allow a bit of time for Q&A at the end. So Paul, over to you. Thank you.
Thanks very much. Morning all, and morning to those that I already know from lecturing on the CIPD course. Nice to see that there's a few of you out there in practice, and that hopefully some of the information and what was imparted during the course has been useful. For those that don't know me, as a bit of background, I'm head of employment and HR at DJM, Douglas Jones Mercer Solicitors. I practiced employment and HR law, specialised in that area for probably the last 15 years. 5 or so years before that was a commercial lawyer, commercial litigator, insolvency, commercial contract disputes. So I've always been involved in that type of work, and as I say, that's been for the last 20 odd years. But 15 years or so, specialised in employment and HR, and that's all I've done. I've done some lecturing as well, CIPD course, as we touched on, and say a couple of students there who would have been on that course. That was at Trinity I did that for 4 years on the level 7. Also done a bit of sports law lecturing down at Swansea University as well, and some bits and bobs for them. So, yeah, just a bit about me and my background. As far as today is concerned, yeah, Power Hour might be a bit grand. Hopefully, some of what you get from today will be of use. And what I've tried to do is to focus maybe on some core aspects of employment HR law. So maybe aspects or issues that you'd be looking at when you're first in business or first coming into this area. Disciplinaries and grievances, something that perhaps most of us will touch on a fairly regularly but not too regular basis. And termination. And what I've done, or what I will look to do there, is to look at that from the perspective of maybe what you should be considering if you are looking at terminating employment for any reason. And the way I look at that in practice normally with clients is to work back from what the employment tribunal would consider if you dismissed an employee and that was challenged and they brought a claim for unfair dismissal. So I'll always say to clients, look, let's work back from that. Let's understand how the tribunal will view it, and then we can put in place what we need to protect our position as much as we can in the event that we are challenged. So it's a whistle-stop tour. As I said, I think I've got, or I said I would restrict myself to half an hour. I probably could go on longer than that, but those 3 elements, the employment contracts, disciplinary grievance, termination, we'll whip through. I will try and give practical examples where I can, because I think that's always useful. And talking to Steve at the outset there, that's something that I try to do in the lecturing work as well, is not just to lecture at you for however long it may be, a couple of hours on black letter law, because everybody falls asleep after a quarter of an hour, but to try and keep it interesting, bring in practical experiences, and certainly as far as the Q&As are concerned at the end, if you've got practical experience that you can introduce or examples you can give, then yeah, that's great, because as I was saying to Steve again, I learn from that myself, because it's good that I can pick up what happens out there on the ground with individuals that are dealing with these issues on a daily basis. So as far as the first topic is concerned, employment contracts, it's surprising how often I'm asked by clients, do we need contracts of employment? Do we need to give employees contracts of employment? The answer to that fundamentally, as you all know, is yes. And the reason for that is twofold, really. Obviously, there's your legal obligations, which I touch on and which I'll work through here. But of course, having a contract in place also creates certainty for all parties, doesn't it? You both know what's expected, what the rights and obligations are. And in the event of a dispute or in the event of a query, you can refer back to the contract and say, well, this is what we agreed. This is what we agreed on this aspect. This is what we agreed on holidays. This is what we agreed on working time, etc., etc. So you have a document, you've got a contemporaneous document you can refer back to. That creates certainty for everybody. So, yeah, do we need contracts? You do legally, but also, it certainly is best practice to have something in place that sets out what the parties' agreements are. Variation, just something that I've not really touched on in the notes, but I often get asked, if we vary a contract, do we need to provide a complete new document? The answer to that is probably no. You can normally deal with that by way of side letter. And what I'd recommend there is you provide the employee with a letter, which I draft for clients, so something that we can do, which sets out what the proposed change is, what the variation is, what clauses are being varied. They sign it off. You stick that with their HR file or with their contract, and that's sufficient to cover off the variation. So as far as the contracts generally are concerned, as I touched on at the outset there is a legal obligation to provide, and since the 6th of April, there's a reference in the notes, you're required as employees to give employees a written statement of particulars, and that's sometimes referred to as a Section 1 statement, which, as I say, there is Section 1 of the Employment Rights Act 96, or the ERA, as you'll sometimes see it referenced. So you have that obligation, and that's let's say relatively new within the last 2 years, and there's no minimum service requirement there. Previously, for those of us that have been around long enough, you recall that you had maybe 2 months to provide a contract. Now that's what's called a day one right, so you have to provide those terms no later than the beginning of employment. Now, you know, that is best practice. There might be some lag there, clearly, with everything else you've got going on in the businesses and everything else you have to juggle, but you need to get that done as soon as possible, really, after the beginning of employment. As to what goes into the document, well, I've set out the list there, and over on to the next slide, and you'll all be aware of what should be included, but a useful referencer maybe if you are looking at what needs to go into perhaps an offer letter, because you can cover off these terms in an offer letter. Previously, that would have been referred to as a written statement of particulars, again, for those of us that are a bit longer in the tooth, maybe. But that written statement of particulars, the breakdown of rights and obligations potentially can be set out in a document. Doesn't have to be a formal contract as such, but it needs to be set out somewhere so that the employee can see that and understand it. So what have we got in there? Yeah, the basics. The names of the parties, the date their employment began, whether there's any continuous employment from a previous employer that counts towards their ongoing employment. Why is that important? Well, again, certain rights are developed and accrued over periods of time. Once you get past 2 years as an employee, as you'll know, you're protected from unfair dismissal. So yeah, continuous employment is important, that it's set out if there is ongoing employment that's transferred in from a previous employer. Rates of pay, intervals of pay, so you paid weekly, are you paid monthly, how's that dealt with? Hours of work and days of work, again, you see the standard contract terms. Your days are Monday to Friday, your hours are 9 to 5, lunch break of whatever, but that has to be set out in the document as well. Holiday entitlement, normally you see the standard, which is the 28 days, 20 days plus the 8 bank holidays. Obviously there was an extra bank holiday this year, so it would have been 9 this year, but 28 is the norm. Again, that needs to be set out. Notice is important. What notice period is expected from the employee if they look to resign, and what notice period can they expect from you if you look to terminate employment. Statutory notice periods are normally set out, and again, as you'll all probably know, statutory notice is 1 week for every complete year of service, up to a maximum of 12. And again, lots of contracts that we'll draft will simply be put on that standard statutory basis. Certainly for maybe more junior employees, if you like, once you get into maybe senior employee territory and directors, then again, as you know, notice periods are normally longer, so you perhaps see 3 or 6 months. But the statutory notice period, a week for every complete year of service, maximum of 12, that's a minimum. You can't give any less than that. And again, basic contracts, junior employees are normally drafted on that basis. Job title, again, that's important. You know, what's the individual being employed as? what's expected of them. Sometimes you will build in some flexibility into that, so there might be wording that says, "Oh, such other role as we may require from time to time." The contract might state that, and normally you would want to give yourself that latitude as an employer, but of course any variation of that kind would have to be reasonable. So you couldn't employ somebody as a manager one day and say, actually, we're varying your role and you're going to be cleaning the out and sweeping the grounds and cleaning the toilets tomorrow. It would have to be something, that sort of variation, that was commensurate with the role that they're already in, the seniority, levels of pay, etc. And generally, just touching on their variations, and I reference variations at the outset as well. If you're looking to vary a contract, normally you'll need the individual's consent to do that. Sometimes you'll see a variation clause in contracts which says, it's normally tucked away at the end of the document, which says, we're able to vary these terms provided we give you sufficient notice. As an employer, we need to be aware that that general clause for variation is only really effective in limited circumstances and for minor changes to the contract. If you're looking at significant changes, so changing hours, changing rates of pay, changing jobs, etc., then you will need to consult with the employee. You need to get their consent if possible. If you can't get consent, then there are certain options open to you, but they come with potential risks. You can push the variation through, but you need to be aware, if you're doing that and the employee isn't consenting, that you possibly could face arguments for breach of contract and also constructive dismissal. Technical considerations for another day, but the point on variation is variation clauses are limited in effect, and if you're looking to vary, then normally you'd want to be speaking to your employees and looking to gain their consent to that variation. Also then, whether the contract is permanent or part-time, fixed term, whether sometimes you see contracts that would be for a fixed period, that may be dependent on funding or for a project. Just very briefly, just be aware there that if that fixed term takes the individual over 2 years employment, then they will be protected from unfair dismissal. So at the end of that 2-year period, you couldn't simply say, okay, we're terminating now and we don't need to go through any process because the contract is only for that limited period. The employee will have accrued certain rights during that time, and so you'll need to go through a full and proper termination process. Probationary periods, not all contracts, again, for senior employees, it's less likely, but if you're employing junior employees, then yeah, you'd probably want a probationary period in there. That clause would normally say probationary period of 3 months. You'll be reviewed during that time. We can extend the probationary period if we wish, and we'll inform you of that. And also, we'd normally put a provision in there that says if you're absent for any significant period of time during the probationary period, then we can add that time off onto the end and extend the probationary period by that time frame as well. So yeah, more junior employees, clearly probationary periods, but you'd want those little nuances in as well there to give you flexibility if you wanted to extend the period, or if the individual had been off sick, that you could add that term on at the end just to extend the period. So then that's the points above that I've just whipped through there. Those are what you need in, as I say, if you were issuing a letter setting out the terms, which wouldn't be a contract, but would just be a written statement of particulars. Those are the core elements that you want in. You can give this following information then in instalments, but no later than 2 months after the beginning of employment. Terms relating to the pension, any training entitlements, notes in relation to disciplinary grievance procedures, which will be the next topic that we'll deal with. Training, just as a point on that, I would always when training's referenced in the contract, draft in a clause that says if you leave within a certain period and we've paid for training, you will repay us a certain part of those training costs. You know, if you leave within a month, you'll repay us 100%. And then normally that would go on a sliding scale, depending on how long they've been in the business, how much they would have to repay. We sometimes see clauses where it's just a flat rate and it says if we pay for your training and you leave, you repay us the full cost of that. Well, those clauses won't be enforceable. What the tribunals and courts have said is that that recovery should be incremental and should drop off 100%, 50%, 25%, whatever the case may be, because if you pay for the training and the individual works in the business, then you're deriving a benefit from that. And if they've stayed with you for 12 months, if they stayed with you for 18 months, then it's not right that you should have that benefit and they should have to then repay you the full cost of the training. So those clauses, training recovery costs, will always be drafted on a drop-off incremental basis over a period of time. And you want those, if you are paying for training, you certainly want those clauses in your contract. Notes on disciplinary grievance procedures. Again, I'll touch on this when we work through, but I would always make those processes and procedures non-contractual. Okay? Because as I said earlier, if you're looking to vary the contract, then you normally have to have the employee's consent. Now, for those types of policy and procedure, disciplinary and grievance, if you're looking to change them or if you're looking to implement different processes, you wouldn't want to be going to, or have to go to the employee to get their consent to those changes and get bogged down maybe and they're not agreeing and, you know, that becoming a drawn out process. So disciplinary grievance procedures, although they might be referenced in the written particulars or in the contract, you would always state in the policy that they're non-contractual. And that gives you scope then to vary them without having to go to the employees and get their agreement or consent. Those details then, the last but one bullet point there, they can be given in a contract or a letter of engagement, as I said at the outset. If you fail to provide them, what's the sanction? What's the potential fallout? Well, there's no standalone claim to employment tribunal for a failure to provide, but if you haven't given an individual a contract, then if there's a claim brought to tribunal on some other basis, and we normally see these claims tacked on in unfair dismissal claims where the individual brings the main claim, the substantive claim, if you like, of, let's say, unfair dismissal, and then they also say, and the employer's failed to provide me with a contract of employment, and I make a claim on that basis as well. And the tribunal can then award up to 4 weeks' salary as compensation for failure in that regard. So that's a bit of a gimme for employees in those circumstances if you haven't provided the document. So again, protect yourself in that way by getting the document provided, by getting the information set out, getting it signed off by the individual. So you're complying with your legal obligations. And again, as I said, as far as clarity and certainty moving forward, you've also then got that document to refer back to in the event of disputes or queries in the future. So that's a quick whip through employment contracts, section 1 statements, most of which you'll be aware of. Hopefully a couple of the sort of practical points I made there on drafting might be of use if ever you're looking at what you need in those documents and maybe fine-tuning what you have in practice. Disciplinary and grievance procedures. So what I intend doing here is not necessarily looking at what a policy would look like and what a policy would have in it, because they'll be fairly standard. You know, if you have a grievance, you report to X. If you want to appeal, you report to Y. Disciplinary, you know, these are what we regard as disciplinary issues. And then you've got a long list of what could potentially be regarded as misconduct, gross misconduct, etc., etc. So the policies themselves will look fairly standard. What I wanted to look at more was process. What a good disciplinary process looks like, if you like. Now, a As far as the policies themselves, just to touch back on that, non-contractual, as I said there, I've explained that, because if we want to vary them in the future, we always want them to be non-contractual, so we're not getting bogged down in consent, consultation, discussions, etc. So the process, what steps should we go through in order to make our process as watertight, potentially, as it can be? Now, you're never going to be, from practice, from 20 odd years of practice, you never have a policy or a process that will prevent claims completely, because at the end of the day, if you dismiss somebody and they've got 2 years service, then they have the option, if they're not happy with the termination, how that's come about, they have the option to present a claim to tribunal. So you can't prevent that, but what you can do is you can protect yourself as much as possible from challenge, and you can show, if you are challenged and you get to the tribunal, you can show the tribunal that you've done things properly, and the next topic I'll deal with as well will cover that, but you can show them that you've dealt with it properly, you understand the process, you've adopted a fair process, it's been transparent, the employee's engaged in that. So you've done as much as you can. So, challenge should be limited. So what does the process look like normally? Suspension. We don't always see that, but maybe for more serious allegations, that would be the first step. You get the individual in, you give them the letter that says we're suspending you on the basis of misconduct issues, whatever the case may be. The letter doesn't necessarily need to spell out in detail what the allegations are. Normally doesn't. Suspension, as I've said there, normally you would want a contractual right in your contracts of employment that allows you to do that. The suspension should always be paid, and the letter will normally reference that, and the letter will also say that the suspension shouldn't be regarded as a disciplinary sanction. It's a neutral act, if you like, on the part of the employer, and that it will be kept under review and will be reviewed at relevant periods along the way, and won't extend more than, and normally you'd have a time frame in there as well. So you've got the contractual right, it should be paid, sets out how long it'll be for. The cars and phones question that I've tacked on at the end there, this is perhaps a practical example of where problems can arise. I acted for many years for a large national contract cleaning company, and they had thousands of field agents, individuals out there working in the field, cleaning remote sites, whatever the case may be. Now, they all had cars, they all had mobile phones, and when issues arise, which were pretty frequent, so they were quite good clients because they were always coming to me with problems, and there was lots of work coming from them, which was good. But whenever issues arose and they suspended these field-based staff, they would always go in and take the car away and take the mobile phone away. And my advice was, look, that presents difficulties, because if these are contractual entitlements, and if they can use the phone for limited personal calls, and if they can use the car for limited personal use as well, we could be in breach of contract here, and we probably are. And also, it could lead to arguments from the individual. Well, even though your letter says this is a suspension is a neutral act, you're imposing some sort of sanction here because you're taking these contractual entitlements away from me. So you'd always get the argument, well, you're prejudging. And invariably, when we'd get to tribunal, when these individuals were dismissed and we'd get to tribunal, the client would always take, our barrister would always take an absolute hammering at the outset for this issue. The judge would always say, look, why did you take the car away? Why did you take the phone away? They're contractual entitlements. You've expressed it as a neutral act on your part, where you're investigating and no decisions have been formed and no sanctions have been imposed, but you've gone in and done this. And that always placed us on a difficult footing, which at tribunal, from a tactical perspective, you want to keep the judge and the panel on side if you possibly can. But that always put us in a difficult starting position because, as I say, the judge would come down really heavily on that. And then, from a procedural perspective, takes a dim view of where we are, and that's always a difficult place to recover from. So if you're in that position, if you are suspending and you have contractual entitlements that employees have and you're thinking of withdrawing, I would think very carefully about that because it can lead to problems. Next step then is normally investigation. So you appoint somebody to investigate, and at the end of that process, they provide a report to you, and you then decide whether you move to a formal disciplinary, whether it proceeds no further. The allegations are not pursued, found to be unfounded, and you don't proceed. The investigating officer should be somebody then that isn't going to be linked with the rest of the process or involved in, and you'll see my final bullet point there, which we'll come to. I'll explain why that's important. You also want to be aware and alive to the fact that anything that's produced, anything that the investigating officer produces, so a report, emails to HR, etc., if you get the tribunal, will be disclosable at some point. So those documents will come to light. Now, I always have lots of fun with these issues when I'm acting for employees, because I'll always dig down into that, and I've had cases. I've had two cases against the same employer actually, where the first case looked like it was cut and dry dismissal for my client because effectively, or what he'd done was he'd taken his fishing rod into work and gone fishing at some point during the working day, which wasn't particularly good. But and the other one was, it was a health and safety issue, same employer. But what we did was we knew that their investigating officers were always looking for guidance from HR, and weren't really making the decision themselves as to whether it should proceed. They were looking for HR guidance and for HR to press the button on it. So in that disclosure exercise, I'd always push for disclosure of emails coming from investigation officers, any reports, pre-reports that were prepared, or any reports that have been amended. And we'd also always make a Section 7 request under the subject access rights for all information that the company held in relation to the employee, in which named them, and which they were named in, and which referenced them. So you've got a big slew of documents which we work through and pull out all these ones that we thought were useful. Because where then the investigating officer isn't making the decision themselves, or where HR subsequently aren't making decisions themselves, there's lots of case law that says that's not right. That there shouldn't be. It's the investigating officer that should be making the decisions, and they shouldn't be influenced by anyone else in the process. So I've used that, and I've used that in those two cases to push the business then to settle in the claims. The first one should have been stitched on. He'd taken his fishing rods in his car, he'd gone fishing. Yeah, that should have been slammed down for me, but it wasn't, because I was able to dig down into it tactically and say, well, look, the process isn't effective because the investigating officer didn't make the decision. And in the health and safety case, the investigating officer felt that my client shouldn't have been dismissed, but he spoke to HR, and HR emailed back and said, no, we think this is gross misconduct. So he then changes his report, recommends potential termination, and as I say, we dig into that and say, no, not right, process is unfair. And again, that second case on the health and safety claim with the same employer, they settled as well. So in a bit of a long-winded way there, the point to be aware of is investigation reports, your investigating officers speaking or contacting HR, be aware that whatever's in those documents, whatever's in those emails at some point could see the light of day, could come before the tribunal, and could be challenged. Letter of invitation to the disciplinary, standard sets out what the allegations are, what they're based on, what evidence you have, who will deal with the hearing, who else will be there, the employee's right to be accompanied, trade union rep, work colleague, whether they have any disabilities, any issues that need to be considered in advance, and also whether there's any documentation they want you to see. And again, that's a standard template, you all have those, but make sure the information's in there, that full detail is in there as to the sanction, as to the allegation and what that's based on, and what the potential sanction could be. The hearing, again, you'll have dealt with them, you know how these things work. So normally you'd come in, parties sit down, you'd have a scene set, everybody's introduced, and then you as a disciplining officer maybe will have a list of questions you work through. The accompanying person there is an interesting one. As I say, the ACAS code says that the individual can be accompanied by a trade union rep or a work colleague. Dealing with a case at the moment where a trade union rep has been involved and has been particularly forthright as to what can and can't be done and what their position within the meeting is. Now, the accompanying person is a neutral role, effectively. What they can't do is they can't answer questions on the individual's behalf, but the accompanying person can make a statement, can ask questions, and can sum up the individual's position. But what they can't do is they can't take over and start asking questions on the employees, or answering questions rather than the employee's behalf. And also, just from a tactical perspective, what you need to be aware of as well is if you think that accompanying person is being disruptive or is becoming more disruptive, then don't be afraid to say, okay, we need to adjourn the meeting now. We'll have a 10-minute break, a 15-minute break, and set out to them really why you think that their conduct is disruptive. Cooling down period, come back in and reconvene. Lots of clients will do that, and you're certainly within your rights to do that if you think that the accompanying person is overstepping what they're there for. Decision. Normally, you would want to communicate the decision in writing. So I wouldn't normally advocate giving the individual the decision there and then, because what you'll be faced with on appeal is you didn't take sufficient time to consider, and you didn't go away and consider all the evidence. So yeah, you'd normally want to conclude the meeting and say, okay, meeting will end there, and what we'll do is we'll send you our decision in writing within the next 5 days, 7 days, whatever the case may be. Within that decision letter, you've also then would give them the right of appeal, and normally I would allow 5 working days or provide 5 working days for any appeal to be lodged. Appeal meeting takes place in the same way as we just said, and then again, decision from appeal is that final letter that concludes the process. So that normally is what, or the way a decent process would look. So you've got maybe suspension, investigation, invitation, hearing, decision, appeal, decision. So maybe 7 steps in that process to work through. Separating out each function. Now, as I say, what you would want to do if you can is to have different individuals dealing with each stage of the process. So you've got your investigating officer, your disciplining officer, and your appeal officer. 3 separate individuals if you can. Be aware, if you get to tribunal, if the dismissal is challenged and a claim is brought, the tribunal would normally expect to hear evidence from those 3 individuals. They'd want all 3 there, and I would certainly, when I'm advising business clients, want my clients to bring all 3 of those individuals forward as witnesses, provide witness statements, come along to the trial, be cross-examined. The tribunal needs to, or wants to, understand what was the process, what did the investigation look like, why was the decision made by the disciplinary officer in the way it was, and why was the decision made by the appeals officer in the way it was. So when you're putting together those processes, it might be worth thinking initially, look, if we do get challenged, and we do have to give evidence on what we went through. How confident are we in the individuals that we might be appointing being robust enough to get in the witness box and give evidence to support why they made the decisions they did. So just something to consider. Now, as I've said there, the separation out unless unavoidable. In some circumstances, in some cases, your business will have a limited management capacity. So there's only a limited number of people that may be able to deal with these issues. So there might be crossover. You know, your investigating officer might have to deal with the disciplinary, and then you've got the most senior individual in the business dealing with the appeal. You get the other side, the employee's representative or the trade union rep jumping up and down if that's the case and saying, look, this isn't fair, this gives rise to bias, etc., etc. Okay, see that argument to an extent, and the ACAS code provides for that. But there is case law that says if your management capacity is limited, then in certain circumstances, you can have the same individual dealing with maybe two aspects of the process, but they have to approach it objectively, and they have to look at it afresh when they're involved in the next stage. And again, the ACAS code says unless unavoidable. So yeah, if you're in that position and you're facing pressure from solicitor on the other side or the individual's trade union rep, then you have got pushback on it. You can say, well, look, we've got limited capacity, this is what we can do, and we can assure you that the process will be objective and that Joe Bloggs, who's involved in stage 1 and will be involved in stage 2, will consider it completely objectively, and you know there won't be any bias in that regard. So just be aware, if you're in that position and you're facing pushback and hostility from the other side, then you can justify your position on that basis. So that's disciplinary and grievance, and I've set out there the companion work colleague trade union rep. The point with the trade union rep, and I've come across this in practice, is that you don't have to recognise the trade union rep for them to be able to accompany the individual. I dealt with a case many years ago where the employee was on a disciplinary, turned up with a trade union rep, and there wasn't a recognised union as far as our client was concerned, and the client refused the request for the trade union rep to come in to the meeting, and again was absolutely panned at tribunal for that. Luckily, I wasn't involved at the stage where that happened, but the judge pointed out, made the point that, look, you as an employer don't have to recognise the trade union within your business, provided that trade union representative is accredited and is able to accompany members as an accompanying person. They have to be allowed into the meeting. So just be aware of that. The accompanying person only at a meeting where sanctions likely to be applied, so you don't necessarily have to allow the individual to be accompanied at the investigatory stage, because there's no sanction coming from that. But once you get the disciplinary, sanction could follow. They are allowed to be accompanied, and that doesn't necessarily apply in redundancy scenarios. So not everybody's aware of that, but the ACAS code doesn't necessarily apply to redundancy process. But having said that, as good practice, I would always tell employer clients to allow individuals to be accompanied during redundancy process if they request that. I don't see, there's no real issue with that, but you don't have to offer it as a matter of course. But if it's requested, then I'd always agree. Accompanying person, we often get asked the question. Joe Bloggs is in a disciplinary, tells us he wants to bring a family member or a friend. You don't have to agree to that. There's no compulsion. There's no legal obligation on you to agree to that. If Joe Bloggs isn't in the union and work colleagues are not willing to come forward, then you might allow a bit of flex and say, well, okay, we're reasonable employers and we'll allow that, but there isn't a legal obligation. You don't have to agree that if you don't want to. So that's disciplinary and grievance. Unfair dismissal. As I say, what I'm looking at here is, and the way I look at this is, if you're So if we've moved through that disciplinary process and you're now looking at the potential for terminating, what can you do to protect yourself as much as you can in the event that you're challenged? And as I say, the way I always advise clients on this is let's work back from what the tribunal looks at when a claim is brought, the steps that they go through when a claim for unfair dismissal is brought. Made a point at the top there, and I've touched on this a couple of times, but just to re-emphasise, generally an employee must have 2 years continuous service to be able to bring a claim for unfair dismissal. There are certain claims where dismissal can be automatically unfair, and if that's the case, the employee doesn't need 2 years service there. They can bring that's what's called a day one right again. And the example I've given there is discrimination, but also if you're terminated, your employment's terminated for example, whistleblowing, or because you've raised health and safety concerns, discrimination, you don't need 2 years continuous service. You're able to bring a claim there of what's called automatic unfair dismissal. So termination, if we were defending a claim, what does the tribunal look at? So the tribunal looks at 3 elements, essentially. Firstly, did you have a potentially fair reason to dismiss? Potentially fair reasons, as I've set out there, capability, conduct, redundancy. Those would be the big 3, yeah? So in most circumstances, well, in all circumstances, you should be able to tick that box to say, yes, our potentially fair reason for dismissing was conduct, gross misconduct, whatever the case may be. So that's our potentially fair reason. So we can tick box 1. So we get over that initial hurdle. The tribunal then considers whether you acted reasonably in dismissing the employee for that reason. The question they ask is, was that decision within what's called the band of reasonable responses? That an employer, with the information you had in front of you, with the evidence you had, would a reasonable employer have come to that decision? Now, very often, that's where the argument comes at tribunal, is over this second limb, if you like, because as I say, we tick the box to say we've got a potentially fair reason. Did we act reasonably? Tribunal considers that. The third element then is whether you adopted a fair process, whether your procedure was fair. Now, we've just gone through what a fair disciplinary process looks like. So again, we should be able to tick the box there and say, yeah, you know, what we did was fair. We went through that process. We investigated. We wrote the letter. We set all the relevant information, details of the allegation, what the sanction potentially could be, the right to be accompanied. We conducted the meeting. We took time to consider, and we sent our decision out in writing. We gave the right to appeal. The appeal officer then considered the appeal, and we gave a final decision. So our process, we would say, was fair. So from those 3 elements that the tribunal looks at, element 1, did you have a potentially fair reason? We will say we tick the box. We've got the conduct, whatever the case may be. Element 3, did you have a fair process? Well, yes, we did, because this is what we did. These are the 7 steps that we went through, and we've documented, and we can provide those documents, and we can provide the correspondence, and we can provide minutes of meetings. So yes, our procedure was as watertight as it possibly could be. So then, as I say, the argument normally comes around the second element. Was what you did, was the termination reasonable in all the circumstances? So then the tribunal would look at the evidence you had, the position put forward by the employee that was terminated in relation to the allegations against them. You'd also look at, so the tribunal would consider what their disciplinary record was like, length of service, etc. And the tribunal will also expect the persons who would normally be the disciplining officer, would also expect them to explain whether they considered an alternative to termination. If they did, how they worked through that and how they came to the decision that termination was the only option. And if they didn't, why not? So that reasonable aspect, that second limb of, did you act reasonably in all the circumstances in dismissing? That's where the drilling down at tribunal will normally come. And again, as I said, that's why it's important that certainly a disciplining officer is quite robust and knows the process, knows your internal disciplinary processes, and conceivably is able to, at some point, be called to the stand in tribunal to give evidence as to what they did and why. And again, awareness of internal policies and procedures is important, because I've been involved in cases. I was involved in a claim against HSBC for discrimination, and they called a regional HR manager to give evidence, and the evidence was appalling. Our barrister pulled them apart on their maternity policy, their disciplinary policy, their sickness absence policy. They were just taken round in circles and tied up in knots and came across very particularly badly. So it's important, again, that the individuals and officers you're appointing to deal with the processes know their way around policies, procedures, and can if challenged on those, explain their understandings and how they applied the particular facts of that scenario to your policies, procedures, and then how they came to that decision. So those are the three elements. If you're at that stage of, we're considering termination, or we are going to terminate, how do we protect ourselves? How do we make ourselves as difficult a challenge as possible? We'll always look at those three elements. What's our potentially fair reason? Is the decision reasonable in all the circumstances? Does this situation warrant finding a gross misconduct, or maybe should we apply a final written warning or a written warning? What's the individual's disciplinary record like generally? How long have they been with us? All of those things taken in the mix as to whether a decision to press the button and terminate is reasonable. And also, the third element, how does our process look? What do we need to put in place to make sure that we're not going to be challenged on process? Because the thing with that is, at a tribunal, even if you have potentially fair reason and the tribunal accepts that you acted reasonably in terminating, if you get the process wrong, if your process is defective for whatever reason, then the tribunal can still make a finding that the dismissal was procedurally unfair. Okay, so even with the best reason and the best reasoning, you could still be falling foul. And the example I always give there is theft. So you've got employee comes to us and says, we caught Joe Bloggs with his hands in the till. We're going to dismiss him. We're just going to terminate him now. And the answer to that always is, well, okay, if you do that, you'll be challenged, you'll be at tribunal, and that dismissal will be found to be unfair, which clients very often have a very difficult time in comprehending and taking on board. But it's for that reason, because they could point to the three elements and they can say to the tribunal, well, yeah, Joe Bloggs stole X from us, and we know he did it, and we've got the evidence, he was on CCTV, whatever the case may be. So that's gross misconduct. So there's our first limb, potentially fair reason, gross misconduct. Was it reasonable? Well, yeah, clearly it was, because we can't have individuals that are stealing from the business. It's not reasonable that we should retain them, and nothing short of dismissal is appropriate in the circumstances. So we take box 2. What process did you undertake? Well, we just dismissed them on the spot. Well, that's where you fall down. And it does. Sometimes it seems a bit counterintuitive, but you still have to work through the process. You still have to invite them to the meeting. You still have to have a disciplinary. You still have to give them a right of appeal. Clients very often don't want to do that. They think it's overkill. But as I say, what you're doing is you're protecting yourself if you get to tribunal, because if you don't, invariably that dismissal will be found to be unfair. And as far as an unfair dismissal claim against you is concerned, the burden of proof, so the burden of showing what you did was fair, is on you. You have to establish that at tribunal. You have to show that at tribunal. So, as I say, at the outset, when you're consider those three elements and frame what you will do from that point forward on that basis, and make sure that you cover off as much as you can. You document, you keep correspondence, and that if you get to tribunal, then that you can protect your position as much as you possibly can in those circumstances. Over the page then, process, I've just touched on that, and I've looked at that previously, the companion as well. And as I said, can address the hearing, put the case, sum up and respond to views, but not ask questions. And again, remember, you don't have to recognise the union in order to allow that individual to act as a designated companion. And that's it. So that's a whistle stop on termination, unfair dismissal. I think I'd probably overrun my time there by going on slightly, but I'm happy to take any questions or any other issues that you've got if you want to fire away with those now.
Thanks, Paul. That was really super. Probably slightly unfair on us to try and get you to uncover employment law in 30 minutes. So I think we did pretty well, to be fair.
I should have narrowed my subjects down.
Yeah, we are a bit tight for time. If anyone's got any burning questions, we've got time for one or two. If anyone wants to, there's a little reactions button at the top. If you want to raise your hand and put your hand up, we've probably make time for one or two if anyone's got anything that they particularly want to cover. Yeah, so Janie, first of all, let's come to you. You're on mute, Janie.
Sorry, can you hear me now?
You can hear you.
Yes.
Yeah, super. Go ahead.
Okay, just a scenario here. You take on a new employee and you train them for 4 days.
Yeah.
But at the end of that 4 days, they say, "Oh, look, really sorry, but I've got a new position, and thanks, but no thanks." Do you have to pay them for those 4 days of training?
I would always recommend it. You often get asked the question about notice periods for that length of time as well. Are they entitled to notice? So, but yeah, I would recommend it. Very often clients are hard-nosed and say, well, we're not going to. And that applies in lots of scenarios, maybe where, there's only a limited period of employment or individuals haven't turned up for work. Very often clients will say, well, look, I'm not going to pay it. And if we're challenged, then I'll consider it then. But normally my advice would be, if they're in the business and working in inverted commas and you've given them a contract and the contract sets out the position as to pay in hours, then my advice probably would be to pay on that basis. But as I say, I know lots of clients who are hard-nosed and say, well, we're not going to, and we won't unless and until we're challenged, and those type of claims won't reach tribunal anyway. For that, for maybe individuals not earning large amounts of money, those claims won't be worth taking forward. So very often clients say, well, we're not going to do it. We won't be challenged. So they can complain, but we won't pay.
Okay. And then if you ask them to put their resignation in writing and they fail to do it, where do you stand then?
The point with that, I think, is, and it goes back to the 2-year qualification for unfair dismissal purposes, unless there's any hint of anything discriminatory in the background which could give rise to an automatic unfair dismissal claim. They then haven't got the comeback to say, well, actually, I didn't resign. You terminated my employment and you forced me out. So it's not as much of a concern. I would in those circumstances, maybe follow up with an email to say, look, this is just to confirm that you told us that you wanted to tender your resignation. We've proceeded on that basis. We've asked you to submit the resignation in writing, but we haven't seen that as yet, or you failed to do so as yet. And so, we're just summing up the position here as to what we discussed and what you told us. And, we'll process your leaving accordingly. So at least then you've got that contemporaneous document if ever you need it in the future to say, well, no, because what sometimes happens is you get individuals that maybe then will try and sort of shoehorn in some sort of discrimination claim to say, well, I was forced to resign because of X, Y, and Z, and so I don't need 2 years service and I've got an automatic unfair dismissal claim. Well, if you've got that contemporaneous document, you might well have to defend a tribunal claim in the early stages, but at least you can say to the tribunal, well, look, here's the position, this is what happened. They weren't dismissed, we didn't dismiss them, and we certainly didn't discriminate them against them in any way. Rather, they told us that they wanted to resign, which we acknowledged in writing, and here's a document that confirms that. So yeah, you can push, but if they don't, I would always send that either summing up letter or email just to set out what your position was and summarise the events that led to the individual resigning.
And if they put an informal resignation through a text message, can you accept that?
Well, what's informal? I wouldn't really, from a technical perspective, recognise that. I always deal with a case recently where clients have got issues with this type of scenario, but I'd always recommend that anything of that nature isn't done via SMS or WhatsApp or anything of that kind, that you get written confirmation if at all possible. But if it happens and you're not getting anything further than that email to HR or whatever the case may be, then I would certainly follow that up and say, look, we'd normally want resignation in writing, can you supply that? And then we're into that scenario that we've just discussed with it. If they don't, you'd follow on and say, look, we've asked you to provide this formally following the email. You haven't done that, but this now summarises the position, and we'll proceed to process your leaving accordingly. So yeah, I'd actively discourage that type of what should be formal correspondence being dealt with on messaging or WhatsApp or anything of that kind. So you want to keep it as formal as you possibly can.
Okay, great. And then last question.
Yeah.
As a small company and you don't have anybody really experienced enough to do the whole investigation disciplinary process, so as a director, really you've got to do all three.
Yeah.
Is that risky, or is there a suggestion? Could you maybe say, if I was to do the investigation and the disciplinary, then if there was an appeal process, could you sort that out to an external consultant?
Yeah, you can certainly do that. I've got clients that have done that in the past. So, and sometimes you get businesses who say, okay, well, we'll bring our accountant in, or we'll bring somebody professional in externally to deal with that. So yeah, that's certainly not a problem, and maybe it adds a layer of reasonableness to what you're doing, because you're saying, look, we did as much as we could internally, but of course we want to ensure that it's looked at afresh at that stage, and therefore what we'll do is we'll bring in, we'll instruct an external HR consultant, or we'll ask our accountant to deal with it, or somebody of that nature. But yeah, that's we see that quite a lot in practice, and there are there are businesses out there, there are consultants out there that will come in and do that for you. Now, one question or one comment that sometimes gets thrown into the mix then by the businesses, well, if we're bringing in somebody external, they might make a decision that probably isn't based on the feeling within the business because they're external and they're not, they're not involved and they're not invested. So it might be a decision that we don't particularly like. Well, yeah, but you have to be prepared for that. Not that I'm saying internal processes are going to be biased, but if you're bringing somebody in external, then of course they're not involved with the business on a day-to-day, and so they will be looking at it completely objectively and completely afresh. So you have to be prepared for, as I say, the potential that the decision might go against what you've already decided.
But which is fine, because the whole purpose is you want it to be a safe sort of dismissal. So yeah,
that's right. But yeah, that certainly wouldn't be unusual, and there are lots of organisations out there that they'll assist on that basis.
Great, lovely. Thanks very much for that.
Thank you, Jamie.
Thanks.
Steve, is it a quick one?
You're going to tell me off, I know, Matt, but I've got to ask this one. I've been dying to ask. Sorry, Paul. Really sorry. I don't expect you to go into all the variants with regards to this, but I'm just interested in, say, for example, you've got an employee charged with a non-work related crime and non-remanded in custody, and you potentially have concerns over the reputational damage to the company or perhaps the health and safety to employees. Where do you stand on the disciplinary process suspension? Obviously, running that alongside a potential court case. Obviously, there's costs incurred to suspending someone if it's going to be elongated court case. There's a lot of things to consider, but what's your general advice?
General advice is you don't have to wait, and I'll give you an example of a case I was involved in where my client was suspended when the police investigation was ongoing. It was an allegation of fraud. And because of the nature of the allegation and the complexity of it, it took about 2 years to get to criminal trial. So yeah, and there's case law on the point that says you're not obliged to await the outcome of the police investigation. But of course, your action on how you take that forward then brings us back into the reasonableness sphere, doesn't it? What's the evidence? What are the issues? What's the potential impact on the business? So you can consider all of that and make a decision based on that. And of course, I say of course, but the standards of proof in civil cases and criminal cases are different. In a criminal case, the judge or the jury has to be satisfied beyond reasonable doubt that there's guilt, whereas you in an employment or a civil forum only have to be satisfied on what's called the balance of probabilities that the individual is guilty of what's been alleged. And the balance of probabilities means, to put it another way, that you're 51% or more certain that they did what's been alleged. So yeah, those elements will be brought into the mix, and again, the question would be: was it reasonable? Was it reasonable for you to dismiss in those circumstances, based on the evidence, based on what the individual had put forward? But from a fundamental point, there isn't anything that says you have to wait until the police have concluded their investigation or there's been a criminal conviction. There's nothing that potentially limits you in that way.
That's great. Thanks, Paul. Brilliant.
Okay.
Fine. And I've just got a very quick one to sum up with.
Yeah.
In terms of the changing environment of the last 2 years with regard to COVID, I guess I'm particularly getting at the workplace environment and the need to work from home or in the office. What's your view in how that's changed and how employment law reflects that?
It's interesting that I think there's certainly been a move towards people getting back into the office, talking from experience where we are. I think the feeling now is that perhaps with lots of people that they want to be in and they want to be back in the office and working. And I think that certainly from the industry we're in, I feel like it's more from a sort of knowledge sharing perspective and a team perspective, where it's easier to sort of discuss and look at different issues and get different views from people on different aspects of different cases when you're in the office. And able to do that. But yeah, you know, I think there will hybrid working will continue, and I know that there's ongoing government consultation, I think, as to whether, you know, flexible working should be something that's offered and should be a standard. But yeah, as far as COVID's concerned, there's you see cases coming through of individuals that refuse to work on health and safety grounds because of concerns. The ones I've seen come through, invariably they've not been successful. So yeah, I think hybrid working will continue, but from what I'm seeing and from clients I'm speaking to, there seems to be a drive now to actually get staff back into the office and get them working back on site.
That's super. Thank you for that. Right, I will wrap it up now because we've run 10 minutes or so over. I don't apologise for that because I think there's been some really useful content today. So thank you, Paul, for that, for your presentation and covering the Q&A at the end. There's some really useful content for that. You've had quite a lot thrown at you, so I'll just reference you again to the fact that this video has been recorded and will be uploaded to our YouTube channel either later this afternoon or tomorrow. So if you wanted to go back and re-watch any element of that, it'll be on our YouTube channel for you to go and watch at a later date. And just flagging up a couple of videos that have been uploaded recently, not unrelated to this, but we did a Startup Enterprise Club sort of 2 or 3 weeks ago on hiring new staff and recruitment best practice. So if you're in that position of hiring your first member of staff in the context of what we discussed today, that might be useful as well. And we did a session, normally these, as you're aware, are recorded in front of a live audience. We did one that was pre-recorded on the customer experience, and that was done in conjunction with our Mystery Shopper Shop Doctor program aimed at hospitality and retail businesses. But the video is broader than that, so anyone that's got a customer base and deals with the public, I would urge you to go and watch that at some point as well. So that's on our YouTube channel where you can find that there. So in terms of what we've got coming up, Startup Enterprise Club, Steve, very quickly.
Yeah, well, date to be confirmed, but there's going to be a session on accounting best practice for small businesses. So you can have a look at the Business Swansea Eventbrite page for more details.
It'll be a green, low-carbon business event, but more focused on how you can reduce your energy costs as a business, which, given the current climate, is something which I'm sure you'll find really, really valuable as well. So again, date to be confirmed, but that'll be week beginning 25th of July. So keep an eye out for our business e-newsletters and social media feeds for details of that in the next week or so. So thanks all for coming today. Hope you found that useful. Thanks again to you, Paul, and we'll leave it there. Thank you all.
Thanks.